Matthew Mansour, Assistant Public Defender, with and on behalf of Exton. Here's my right. Exton, can you state your name for the record, please?
Deja Exton.
I have before me a plea form that indicates that the defendant would be pleading guilty to added counts 3 and 4. 3 being attempted possession of a loaded firearm in a motor vehicle, the 1-year offense. And count 4 being use of a controlled substance, also the 1-year offense, also a 1-year offense. Upon her successful plea to those charges, counts 1 and 2 would be dismissed. That's the court's entire understanding of the agreement.
That's correct, Your Honor.
That's correct, Your Honor.
May I have her sworn?
Raise your right hand. You solemnly swear and affirm the testimony you're about to give the truth, nothing but the truth, so help you God.
Yes.
State your name.
Deja Exton.
Ma'am, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that correct? First is the charge and added count 3 of attempted possession of a loaded firearm in a motor vehicle. That's a misdemeanor punishable by up to 1 year incarceration, a $1,250 fine plus court costs, and mandatory forfeiture of the weapon. You understand that?
Yes.
Count 4 is use of a controlled substance. That is also a misdemeanor punishable by up to 1 year incarceration and or $2,000 fine plus court costs. Do you understand that?
Yes.
You also understand, ma'am, while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Freshour in the 14A4 District Court.
Yes.
Still wish to plead guilty?
Yes.
Were you in a motor vehicle?
Yes.
Did you have a weapon in that vehicle?
Yes.
What was it? Was it a pistol?
Yes.
Where was it located?
Under the seat. In the Kia Soto.
I'm sorry?
In the car, in the Kia Soto.
Got it. You don't have authority to carry a weapon in that fashion. It was in the passenger compartment, correct?
Yes.
You don't have permission to carry it in that fashion that you were carrying it, do you?
No.
All right. Did you also have in your possession heroin and or fentanyl?
Yes.
Had you used it?
Have I used it? Yes.
Had you used it? Okay, and you knew what you were using was heroin and or fentanyl?
Yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied, Your Honor.
Court will accept the defendant's plea of guilty. 2 counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A4 probation. Sentencing in this matter will be
April 23rd at 9 a.m. before Judge Freshour.
April 23rd, 2024, 9 a.m. before Judge Freshour.
Your Honor, my client would like me to address bond.
Go ahead briefly.
Thank you, Your Honor. Ms. Exton is Michigan born and raised. She's a Detroit resident. She's a full-time mother with full-time custody of a 3-year-old daughter. She works full-time. Not sure if she still has that job, but she's been employed there ever since November. To my knowledge, she has no open criminal cases. She's not on probation. She's not on parole. Her iChat is clean. Her record of appearances in this court, she's never missed a date. She does not own or possess any firearms. She has no plans to leave the state of Michigan anytime soon. We know she has not been perfect while testing on bond. She has spent the entire week in jail. She had a lot of time to think and reflect on her mistakes. All this time away from her child. Her 80-year-old grandmother is struggling right now, trying to help take care of that child. Your Honor, I'm asking for a PR bond on her behalf, allowing her one final chance to show you that she has learned from her mistakes, and she personally would like to apologize to you herself.
I can speak. Oh,
If you'd like.
I apologize for the way my attitude been perceived in this court.
Perceived?
I apologize. That's not who I am. I had a lot of time to reflect on my actions, and I learned my lesson. I don't want to be that person.
Your Honor, can I speak?
I don't know who you are.
Oh my God.
Yelling from the, who is that? Who are you?
I'm her mother.
Go ahead, man. I need your name.
My name is Heather Gregory. I'm here because she do have a 3-year-old child that's a special needs child. I work all the time, over 60 hours. I just came back from out of town, and my mother is struggling to take care of her daughter, by herself because we just lost my father. If we gotta have on a tether or whatever, yonder, we definitely need her home. Because my mother cannot take care of the child and I work too much.
She explained to you what she did?
She did.
She did not?
She did not. She did not tell.
Okay, let me just put it to you this way, Mom. She's in custody because she worked her way there. I mean, it wasn't just where I just threw her in. She was coming, she had issues over with an attitude problem over at Community Corrections and doing stuff there. I gave her a warning. Didn't lock her up. She was supposed to be testing. She was supposed to be doing everything. Next thing I know, she shows back up here. And she not only has abnormal creatinine levels, which would be positives at any event, I was still giving her the benefit of the doubt, but then shows up with cocaine in her system. That's how she ended up locked up. So the difficulties are not because of anything the court's doing, it's because of what she's not doing and then not telling me the truth.
I mean, like I said, I didn't know the Buddha stand. I've been out of town, I went out of town, you know, so I didn't know what happened. But she was court, I mean, we had lots of her. And like I said, she got a special needs kid, a daughter that has cerebral palsy, my mother is trying to take care of. And it's hard. I know she's not perfect, and I know she has an attitude
Oh, yeah, she does.
problem, which, I mean, she might have got it from me, but I definitely need her home because I got this grandchild that needs her. So all that, Your Honor, I'm just asking, can you please give her another chance? If I gotta watch her, I will, but I definitely need her home for my granddaughter's sake.
Any response from the people?
No.
Thank you. Thank you, Mr. Gunnar. Outside of that, Mr. Why should I even bother letting you out? Because I just have a feeling what's going to end up happening is Judge Freshour is going to have to lock you right back up.
I'm not gonna be the person that I was. And I had time to think in jail, trust me. I don't wanna be there.
$5,000 personal recognizance bond. I'll reinstate previous conditions.
You need to thank him.
Thank you, Joe Simpson.
Thank you, Your
See
Honor.
what?
She would get a different date.
Yeah. Different. But hold on. Reinstate the previous conditions. Also indicate that there's to be no further tests. I will also order a GPS tether. Home confinement, except work. I'll be sending a note to Judge Freshour, so young lady, if you mess up one bit, trust me, you'll be right back. Understood?
Yes.
Thank you.
Thank you, Your Honor.
The courtroom grows quiet as a serious criminal. Case moves forward with a plea hearing that could determine the defendant's immediate future. What begins as a straightforward legal procedure soon turns into an emotional moment involving family, accountability, and a judge weighing whether someone deserves another chance. At the start of the hearing, the defendant's public defender steps forward and explains the agreement reached between the defense and the prosecution. According to the plea deal, the defendant will plead guilty to 2 misdemeanor charges: attempted possession of a loaded firearm inside a motor vehicle and the use of a controlled substance. Both of these charges carry potential penalties of up to 1 year in jail. However, in exchange for her guilty plea to those 2 counts, the more serious charges originally filed against her will be dismissed. The judge carefully confirms the details of the agreement before moving forward. The defendant is placed under oath, and the court begins the formal process of establishing the facts behind the charges. The judge asks, A series of direct questions to ensure that the defendant understands exactly what she is admitting to. First, the court addresses the firearm charge. The defendant admits that she was inside a vehicle when a pistol was present. When asked where the weapon was located, she explains that it was inside the vehicle within reach, specifically in the passenger compartment. The judge clarifies an important legal point. She did not have the legal authority to carry the weapon in that manner. The defendant acknowledges that she understands this and confirms that she knew the firearm was in the vehicle. The questioning then shifts to the second charge involving drugs. The judge asks whether she had heroin or fentanyl in her possession. The defendant admits that she did. When asked whether she had actually used the substance, she again answers yes. With those admissions placed on the record, the judge confirms that the legal requirements for accepting the guilty plea have been satisfied. The court formally accepts the plea agreement and dismisses the remaining charges as promised, but the legal process does not end there, because sentencing will take place at a later date before a different judge. The court orders a pre-sentence investigation report to be completed. This report will allow the sentencing judge to review the defendant's background and circumstances before deciding the final penalty. The sentencing hearing is scheduled for April 23rd. However, before the hearing concludes, the defense attorney raises another important issue: the defendant's bond status. The attorney asks the court to consider releasing the defendant from custody on a personal recognizance bond. While she waits for sentencing. In support of this request, the defense presents several factors meant to demonstrate that she is not a flight risk and deserves another opportunity. According to her attorney, the defendant is a lifelong Michigan resident from Detroit. She is also the full-time mother of a 3-year-old daughter and has been working full-time since November. Her criminal record is relatively limited, and she has consistently appeared for every required court date. The attorney acknowledges that the defendant has struggled with compliance during drug testing while on bond, but emphasizes that she has already spent an entire week in jail. Reflecting on her mistakes, he also highlights the emotional impact of being separated from her child, explaining that the child is currently being cared for by the defendant's elderly grandmother, who is struggling to manage the responsibility. The defense asks the judge to give the defendant one final chance to prove she can follow the court's rules. The defendant herself then addresses the court directly. She apologizes for how her behavior may have been perceived in previous hearings. She tells the judge that she has had time to reflect while in custody and insists that the version of herself the court saw earlier is not who she truly wants to be. But the courtroom moment becomes even more emotional when another woman stands up and asks to speak. She identifies herself as a family member and explains that she is there because of the defendant's young child. She tells the judge that the family is struggling to manage childcare responsibilities while the defendant is in custody. The woman explains that she works long hours and that her elderly mother, who is trying to help care for the child recently, suffered a family loss and is overwhelmed. She pleads with the court to allow the defendant to return home so she can care for her child, but the judge responds with a very direct and honest explanation from the court's perspective. The defendant's situation is not the result of unfair treatment or a harsh decision by the court. Instead, the judge explains that the defendant's own actions led to her being placed in custody. The judge recounts a series of problems that occurred while she was previously out on bond. These issues included conflicts with community corrections staff and repeated problems during required drug testing. The judge reminds everyone that he had already given her warnings in the past and chose not to jail her at those earlier moments. However, the situation escalated when her drug tests began showing abnormal creatinine levels, results that can sometimes suggest attempts to manipulate drug screenings. Despite those concerns, the judge explains that he still gave her the benefit of the doubt, but things became much more serious when a later test revealed cocaine in her system. At that point, the judge says he had no choice but to take action. After listening to both the defense attorney and the family member, the judge turns directly to the defendant with a blunt question: why should the court trust that things will be different this time? The defendant responds by saying that the time she spent in jail gave her the opportunity to think deeply about her behavior and the direction of her life. She insists that she does not want to return to jail and promises that she will follow the court's rules if she is given another opportunity. For a moment, the courtroom waits as the judge considers the request. Finally, the judge announces his decision. The court will allow the defendant to be released on a $5,000 personal recognizance bond, meaning she will not have to pay money up front but will be responsible for the amount if she violates the conditions of her release. However, the judge immediately adds strict new conditions. All previous bond requirements will remain in place. In addition, the defendant will now be placed on GPS monitoring and home confinement, meaning she will only be allowed to leave her home for work. The judge also sends a clear warning: if she violates the conditions even once, she will be taken back into custody immediately. The defendant acknowledges the conditions and thanks the judge. The hearing concludes with a mixture of relief and tension because while she has been given another chance, it is now clear that the court will be watching very closely to see whether she truly intends to change.